Hello everyone, this is your host Urvashi Chauhan. Welcome to Courts Today by Live Law, your one-step destination to all legal developments in the country. Let us start. An important development has come from the Supreme Court today. The bench of Justices Bela Trivedi and Pankaj Mittal has held that advocates cannot be held liable under the Consumer Protection Act for deficiency of services. The issue, crucial for members of the bar, has emerged from a judgment delivered by the National Consumer Disputes Redressal Commission in 2007, where the Commission had ruled that the services rendered by lawyers are covered under Section 2(o) of the Consumer Protection Act. This section defines service, that is, any kind of offering made available to potential users. This includes various activities like banking, insurance, transportation, accommodation, entertainment, or providing news and information. But it does not include services given for free or those provided under personal service contracts. The NCDRC had stated that a lawyer cannot be held responsible for whether a case goes well or not because the outcome depends on many factors, not just the lawyer's efforts. But if the lawyer fails to provide the services they promised for the fee they received, then they can be taken to court under the Consumer Protection Act. After this, the matter reached the Supreme Court. After hearing both the sides at length, the Supreme Court had reserved the judgment in this matter in February this year, and the verdict came out today. Justice Trivedi read out the operative part of the judgment, highlighting that it differentiates between professions and businesses or trade. A professional like a lawyer or doctor needs extensive education, skill, and mental effort. Their success relies on factors beyond their control. Therefore, professionals cannot be treated the same as businessmen under the Consumer Protection Act. The court has held that a complaint against advocates alleging deficiency of services is not maintainable before Consumer Forum. Significantly, the bench also opined that the judgment in Indian Medical Association versus VP Shantana, which held that doctors and medical professionals can be held liable under Consumer Protection Act, requires it to be revisited. Do tell us about your views on this in the comment box below. In a major development, the Supreme Court today granted bail to Bhima Koregaon accused Gautam Navlakha. Navlakha is a journalist and activist who was arrested in April 2020 for his alleged involvement in the violence that erupted at Bhima Koregaon village in January 2018. Owing to his ill health, the Supreme Court had placed him under house arrest in the year 2022. Last December, the Bombay High Court had granted him bail after noting that there was no material to infer that he had committed a terrorist act as contemplated under the UAPA. However, the bail order was stayed for 3 weeks after the NIA sought time to challenge it in the Supreme Court. Time and again, this stay was extended by the top court. The Supreme Court bench of Justices M.M. Sundaresh and S.V.N. Bhatti has now lifted this interim stay after noting that Navlakha has been incarcerated for more than 4 years and the trial would take years and years and years for its completion. Also, the bail is subject to payment of 20 lakhs for his house arrest. We have been informing you of all the developments in the Patanjali matter. I am referring to the case filed by Indian Medical Association against Patanjali Ayurved for its misleading claims and disparaging advertisements against the allopathic system of medicines. You are aware that the Supreme Court had deprecated the actions of Patanjali Ayurved, which continued to publish advertisements in breach of an undertaking given to the court. In the same case, the court was infuriated with the president of IMA for his statement at a press conference where he criticized the Supreme Court's observation that IMA should act regarding complaints of unethical practices by doctors. The bench of Justices Hima Kohli and Ehsanuddin Amanullah continued to hear the matter today. The president of IMA, Dr. Ashokan, was personally present before the court. He conveyed an unconditional apology. However, the bench was not happy with his conduct. Justice Kohli remarked that Dr. Ashokan's conduct would have to be treated the same way as Patanjali's. If you remember, the court had discarded the apology tendered by Patanjali and its founders. The bench today questioned the genuineness of Dr. Ashokan's apology by asking why he did not issue a public apology before coming to the court. In response, Dr. Ashokan said that he held the institution in the highest esteem. The Supreme Court has granted bail to 2 Kerala lawyers who were arrested by the state police in a case for allegedly raping their client. According to the FIR, in 2021, when the victim sought legal help for a divorce, one of the accused, a lawyer, sexually assaulted her after drugging her drink. He then promised to take care of her like a wife, ensure her daughter's education, and buy her a house. The victim also alleged that the second accused, a colleague of the lawyer, also sexually abused her, and the lawyer recorded nude pictures of her on his phone. Earlier, the Supreme Court had noted from the state's affidavit that the accused had issued a check to the victim, which she in turn encashed. The state had contended that this conduct suggested the involvement of the accused in the crime. Also, the court had noted that the accused had not been arrested till April 2024, though the anticipatory bail granted by the High Court was stayed in December last year. The state's counsel back then had sought time to get instructions. Later, in May this year, the accused were arrested. Now, the bench comprising Justices Rishikesh Roy and Prashant Kumar Mishra has allowed their release on bail. The High Court's order of anticipatory bail was set aside. The court also ordered the advocates to stay away from the victim and any other witnesses involved in the case and not to communicate with them in any manner. The trial court has been given the liberty to impose such bail conditions as deemed fit. Coming to the petition filed by NGOs Common Cause and the Center for Public Interest Litigation, seeking a probe by the Special Investigation Team into the alleged instances of quid pro quo in the electoral bonds scheme. The pleas allege that a scam worth crores of rupees is involved in the electoral bonds matter, which can be explained only through an independent investigation under the monitoring of the Supreme Court. It further alleged that the data which was disclosed to the public after the Supreme Court struck down the anonymous electoral bonds scheme showed that the bulk of the bonds appear to have been given as quid pro quo arrangements by corporates to political parties. Advocate Prashant Bhushan, appearing for the petitioners today, mentioned the matter before the bench of Justices Sanjeev Khanna and Dipankar Datta and requested for an early listing of the plea. In reply, Justice Khanna said that the matter was with the Chief Justice of India and reassured that the CJI with the registry would take a call on the listing in due course. Once more, Sandeshkhali, a small town in West Bengal, is embroiled in a political controversy as the Trinamool Congress and the Bharatiya Janata Party trade accusations. You already know that the women of Sandeshkhali had alleged that they were raped and sexually harassed by TMC strongman Shah Jahan Sheikh and his aides. This prompted massive protests and became a major national political issue ahead of the Lok Sabha elections, leading to Shah Jahan's arrest and subsequent expulsion from TMC. Also, the Calcutta High Court had taken a suo motu cognizance of the issue and directed for a CBI investigation into the allegations. Recently, the TMC has released a sting operation video on social media featuring BJP leader Gangadhar Koyal, who alleged that the rape accusations were made up and instigated by the state opposition leader Suvendu Adhikari. This followed the emergence of several new videos claiming that a female BJP leader coerced women into signing blank papers later filled with sexual assault complaints against TMC leaders. In this regard, an application has been filed in the Supreme Court seeking an independent investigation to ascertain the genuineness of the sting operation video, asserting that the applicant has no political affiliation and was only interested to ascertain the truth of the matter. Senior advocate Dr. Menaka Guruswamy mentioned the application today before a bench comprising Justices B.R. Gavai and Sandeep Mehta for urgent listing. The bench stated that the request would be considered. The Apex Court today dismissed a writ petition seeking direction to the Election Commission of India against hate speeches allegedly given by Prime Minister Narendra Modi and Union Minister Anurag Thakur during the campaigns for Lok Sabha elections. The petition, filed by an ex-IS officer and a former IIM dean, sought a direction to the ECI to initiate appropriate action against the hate speeches being delivered by political campaigners, especially those on behalf of BJP. The bench of Justices Vikram Nath and Satish Chandra Sharma heard the matter. Senior advocate Sanjay Hegde, appearing for the petitioners, pointed out that in 2019, the court had entertained a similar petition and sought the response of the Election Commission. But the bench today was not inclined to interfere in this petition under Article 32. The same bench today refused to entertain another petition seeking to disqualify Prime Minister Narendra Modi from elections for allegedly making hate speeches and invoking religion during campaigns. Justice Nath pointed out that the petitioner had approached the court directly without approaching the Election Commission first. Eventually, the petition was withdrawn. In another update from West Bengal, Calcutta High Court Judge Justice Jai Sen Gupta has recused from hearing a plea by former judge and BJP Lok Sabha candidate Abhijit Gangopadhyay, who seeks to quash an FIR registered against him. In March this year, the former judge had resigned from his post and joined politics. According to the criminal complaint registered against him, Gangopadhyay had allegedly assaulted certain protesting staff belonging to state or aided institutions who had lost their jobs as a result of a recent High Court ruling. It was alleged that Gangopadhyay was part of a rally by the BJP containing party workers who visited the protest site of the former teachers and assaulted them. Gangopadhyay's counsel alleged that the FIR was a political ploy used by the state government to stop him from campaigning and participating in the upcoming Lok Sabha elections. His plea to quash the FIR was today listed before the single bench of Justice Jai Sen Gupta, who recused himself from hearing the matter by stating that he had a close relationship with former Judge Gangopadhyay during their time in the bar and on the bench. The matter will now be placed before the Chief Justice for necessary assignment. The Supreme Court today dismissed a petition filed by Punjab government against the High Court's order which quashed an FIR against Dera Sacha Sauda chief Gurmeet Ram Rahim Singh for allegedly insulting the religious beliefs of Sant Kabir Das and Guru Ravidas devotees. An FIR was lodged against Ram Rahim last year under IPC over a discourse during a satsang in the year 2016, where he allegedly associated Sant Kabir Das and Guru Ravidas with liquor bottles and a prostitute. The Punjab and Haryana High Court had quashed the FIR by noting that the complainant had selectively extracted disconnected segments of the discourse and presented them without proper context. Against this, the state government approached the Supreme Court. Passing the order today, the bench of Justices Sanjeev Khanna and Dipankar Datta observed that the petition lacked substantial merit. While the counsel who was appearing requested for time to file additional documents, the court declined the same, noting that an adjournment was given earlier as well. Let me tell you, Ram Rahim is currently serving a jail sentence of 20 years after his 2017 conviction for the rape of 2 women. He recently made headlines in January when he was granted parole for the 9th time since his conviction. The Supreme Court has quashed an FIR which alleged that a book in the Indore Law College library hurt religious sentiments. The FIR and criminal proceedings lodged were over the keeping of a book titled Collective Violence and Criminal Justice System, authored by Dr. Farhat Khan in the library of the Government Law College Indore. The criminal complaint was filed by an LLM student and Akhil Bharatiya Vidyarthi Parishad leader. Along with the principal and assistant professor at the college, the author and the publisher of the book were the co-accused. They were accused of promoting enmity between different groups and hurting religious feelings. According to ABVP, the book contained objectionable material against Hindus and the Rashtriya Swayamsevak Sangh. In the year 2022, the Supreme Court had protected the principal from arrest temporarily when the Madhya Pradesh High Court did not. Later, the High Court gave him anticipatory bail. In the same month, the State Council told the Supreme Court that they planned to challenge the High Court's decision. CJI Chandrachud was then surprised, questioning if the state had more important matters. Today, the bench of Justices B.R. Gawai and Sandeep Mehta was hearing the SLP filed by the principal of the Government New Law College Indore against the order of the Madhya Pradesh High Court, which refused to stay the FIR against him. At the outset, Justice Gawai questioned as to why the state of Madhya Pradesh wanted an additional Advocate General to appear in this matter, especially on caveat. He suggested it appeared to be a case of persecution with someone trying to cause trouble for the petitioner. The court noted that the book was part of the approved academic syllabus. It observed that the jurisdiction of the High Court under Section 482 of CRPC was to prevent abuse of the process of law and miscarriage of justice, but in this case, the High Court had failed to exercise the jurisdiction. The bench went on to assert that the FIR was nothing but an absurdity and did not disclose the ingredients of any of the offences. Accordingly, the FIR was quashed. In another update, the Enforcement Directorate today informed the Delhi High Court that the Aam Aadmi Party is going to be made an accused in the alleged liquor policy scam. This development came while ED was opposing the plea filed by former Deputy Chief Minister of Delhi and Aam Aadmi Party leader Manish Sisodia in the money laundering case. Earlier, the agency had disclosed before the Supreme Court that it was contemplating to make the political party an accused in the case and invoke Section 70 of PMLA to probe the aspect of vicarious liability. Let me tell you, recently the bench of Justice Swarnakant Sharma had, while dismissing a challenge to the arrest of CM Arvind Kejriwal, held that a political party can be brought within the purview of PMLA. A veiled reference was made today in the Supreme Court to the recent criticism made by economist Sanjeev Sanyal, a member of Prime Minister Economic Advisory Council, who said that judges work for few hours and go on summer vacations. The discussion sprung when the bench of Justices B.R. Gavai and Sandeep Mehta took up a matter in which the Solicitor General was appearing. Since the matter required a longer hearing, Justice Gavai suggested that it could be continued tomorrow as a part heard. Justice Sandeep Mehta then remarked that Supreme Court judges were being criticized over vacations. The Solicitor General Tushar Mehta told the court to ignore ill-informed criticism about the vacations of judges. He underscored the hectic work schedule of judges by pointing out that vacations are not real vacations, as judges spend the time for writing judgments. It may be recalled here that a similar discussion on court vacation took place last week also before the same bench, when Justice Gavai said that people are not aware that judges don't even get weekend holidays as they are occupied with other official assignments. If you wish to know more details about the cases I mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Live Law. Do not forget to like, share and subscribe and support us. You can also support us by donating through the thanks button at the bottom of our videos, or consider becoming a member at just 89 rupees per month.